Hello, this is R.J. Deacon, reading the Supreme Court of the United States opinion syllabus in WesternGeco versus Ion Geophysical, certiorari to United States Court of Appeals for the Federal Circuit, argued April 16, 2018, decided June 22, 2018. Petitioner WesternGeco owns patents for a system used to survey the ocean floor. Respondents, Ion Geophysical, began selling a competing system that was built from components manufactured in the United States, shipped to companies abroad, and assembled there into a system indistinguishable from WesternGeco's. WesternGeco sued for patent infringement under 35 U.S.C. 271 F1 and F2. The jury found Ion liable and awarded WesternGeco damages in royalties and lost profits under 284. Ion moved to set aside the verdict, arguing that WesternGeco could not recover damages for lost profits because 271F does not apply extraterritorially. The district court denied the motion, but the Federal Circuit reversed. Ion was liable for infringement under 271F2, the court reasoned, but 271F does not allow patent owners to recover for lost foreign profits. On remand from this court in light of Halo Electronics versus Pulse Electronics, the Federal Circuit reinstated the portion of its decision regarding 271F's extraterritoriality. The Supreme Court held WesternGeco's award for lost profits was a permissible domestic application of 284, the Patent Act. The presumption against extraterritoriality assumes that federal statutes apply only within the territorial jurisdiction of the United States. Foley Bros versus Filardo. The two-step framework for deciding extraterritoriality questions asks first whether the presumption have been rebutted, RJR Nabisco versus European Community. If not, the second step asks whether the case involves a domestic application of the statute. Courts make the second determination by identifying the statute's focus and then asking whether the conduct relevant to that focus occurred in the United States territory. If so, the case involves a permissible domestic application of the statute. It is usually preferable to begin with Step 1, but courts have the discretion to begin with Step 2 in appropriate cases. The court exercises that discretion here. When determining the statute's focus, i.e. the object of its solicitude, Morrison versus National Australia Bank, the provision at issue is not analyzed in a vacuum. If it works in tandem with other provisions, it must be assessed in concert with those provisions. Section 284, the Patent Act's general damages provision, states that the court shall award the claimant damages adequate to compensate for the infringement. The focus of that provision is the infringement. The overriding purpose of 284 is to afford patent owners complete compensation for infringements. General Motor Corp versus DeVoe Corp. Section 271 identifies several ways that a patent can be infringed. Thus, to determine 284's focus in a given case, the type of infringement that occurred must be identified. Here, 271 F2 was the basis for WesternGeco's infringement claim and the lost profits damages that it received. That provision regulates the domestic act of supplying in or from the United States, and this court has acknowledged that it vindicates domestic interests. See Microsoft Corp versus AT&T. In sum, the focus of 284 in a case involving infringement under 271 F2 is on the act of exporting components from the United States. So the conduct in this case that is relevant to the statutory focus clearly occurred in the United States. Ion's contrary arguments are unpersuasive. The award of damages is not the statutory focus here. The damages themselves are merely the means by which the statute achieves its end of remedying infringements. And the overseas events giving rise to the lost profit damages here were merely incidental to the infringement. In asserting that damages awards for foreign injuries are always an extraterritorial application of damages provision, Ion misreads a portion of RJR Nabisco that interpreted a substantive element of cause of action, not a remedial damages provision. The decision is reversed and remanded. Justice Thomas delivered the opinion of the court, in which Chief Justice Roberts and Justices Kennedy, Ginsburg, Alito, Sotomayor, and Kagan joined. Justice Gorsuch filed a dissenting opinion, in which Justice Breyer joined. Thank you for listening.